Now we're moving on to federal Indian policies and treaties. Hopefully that little bit of overview is enough to get us all on the same page in thinking about the relationship of the federal government and Indian tribes and the effect that it has on treaty making. I created a version of this federal Indian policy timeline when I was in law school because Indian law is hard because sometimes it doesn't make sense. It goes back and forth. And so for me, I needed to figure out what was going on in the federal government and what its policies were. And once I understood that, then everything I studied made more sense. And I've highlighted for you the little red area, which is the treaty period. Now, treaties happened before that period, they happened after that period. But for the United States, because the United States didn't come into existence until 1778, I pull that out as the treaty period because in 1871, there was a statute that came down to stop treaties from being made. So after 1871, there were treaties that were made, but they weren't ratified. And many changes were happening through statutes at that point. You'll notice that the dates overlap. Again, this was made by a student, being me. And some of those dates are debatable. Different sources say different things. But I decided to stick with the dates that I have here. So in our last session, I put up 2 treaties from Fort Laramie, one in the 1850s and one in 1868. I think it was 1851 and the second one in 1858. And I asked, what was the drastic change that happened within that 17-year time period? And so really going through this timeline will address why there are such drastic changes in the scope and language in treaties over time. So my timeline starts out with the colonial period, right? I started at 1460, and you'll notice my timeline because of my learning, my experience as a human being, starts with time immemorial. And for me, that's really important because tribal peoples have been here with their governments, even though they're recognized as governments by outsiders, since time immemorial. And you'll notice the other end of the timeline goes into posterity. On this timeline, I have the colonial period starting at 1460, and that's because European countries were actually going out and making contacts with the United States, but that was just a world overview. Our colonial period kind of starts at the same, what I'm going to discuss today does start that broadly, and then we'll get into the existence of the United States and the colonies. So during the colonial period, that's basically the old world, which is Europe, is coming to the new world. This is happening through different countries. We have sovereign to sovereign negotiations. Then we have the American Revolution. This is going on. The United States government did not exist until the Constitution was created. It was ratified in 1788, and it became effective in March 1789. The topics of those treaties during this time were usually political and military alliances, which makes sense, right? Because you had a lot of different sovereigns vying for land in the New World. So those top and land cessations, so they're coming to the New World, they're seeing it's occupied, and they're like, okay, since we're recognizing you as a sovereign, let's make a treaty. In exchange for this land, we'll give you something. Now, whether or not those were fair exchanges is another historical question that could take an entire semester to discuss, but we will not discuss that today. But it makes sense that those were the topics of the treaties in the colonial period. As an example, I have here treaty, and I'm using air quotes for that, from 1726. And this is a deed in trust from the 3 of the 5 nations of Indians to the king. So this is in colonial New York, and this is a transfer of land, basically, from three of the five Indian nations to the king at the time, which I believe was King George. And here I thought it was important that we see the marks of the tribal representatives that were there. They weren't just X's. They were actually marks that represented them as individuals. Because one of the things that happens when you look at treaties in the formats that we're used to seeing them all typed up, what they say is this tribal individual made their mark, like it's an X. It wasn't always an X. A lot of them had their own signature mark. So I think it's important to talk about that when we look at treaties, which is why it's important to look at the original documents, to actually look at the signatures. And at the bottom here, you can see there are notations of who they're coming from. The individuals are coming from the tribe of the deer, the tribe of the turtle, the wolf, the plover, the bear, the beaver. It just shows you again, highlighting that sovereign to sovereign relationship. I mean, they're dealing directly with the king, right? They're dealing with another sovereign, of course through his emissaries, but that is how it is being viewed. So on to this big treaty period with the actual creation of the United States. So from 1778 to 1871, the United States has come into existence. We have the Indian Trade Act of 1790. So while we are talking about treaties, we'll see that federal statutes are already starting to come into play and starting to influence how treaties are being made or what topics are being covered, including commerce, right? So now it's going to the federal legislature to talk about who is in charge of trading with the Indians, and it is the federal government. And we see the beginning of that trust relationship, right? Because now they're creating statutes, the Congress are creating statutes, putting themselves in as intermediaries between Indian tribes and anyone else. So you see the beginning of it. During this time, we have the Louisiana Purchase in 1803. So we think about that. So there's a westward expansion. We're coming from the colonies and settlers are moving west. And as we go through this timeline, you'll see that there's some overlaps in time periods. And that's because we have a lot of different things going on over time. During this treaty period, over 400 treaties were ratified. That's a lot, and they covered a lot of things. So when we think about treaties, and we looked at some yesterday and we'll look at examples of some today, they usually cover more than one topic. It's not only a peace treaty, it usually has to do with land, it has to do with future interactions, maybe establishing a fort somewhere, sometimes payment in exchange for land, annuities. All types of topics are in these treaties. So I'm pulling out what the main topics were for each of the time period. Oh, there was also the War of 1812 going on. We have that concept of manifest destiny. And this is all affecting why we had so many treaties during this time period, right? Because there were so many interactions with non-Indian people moving into Indian territories. There were hostilities between the two. There was the sharing of resources, not necessarily by choice. Lots of things were happening, and that really underscores why there were so many treaties. And so what were the topics? Peace treaties, military alliances, for instance, the War of 1812, right? The creation of reservations was starting during this time period, and we're going to go into that more here in a minute. But removal was starting to happen. Land cessations was starting to happen. And that's what many of those treaties, particularly the ones that are the later part of this period, were about. It was a displacing of the people that were there so that new people could move in and try to create some notion of peace so that they weren't always warring. They weren't always attacking each other. It's important to note that during this time, there were lots of federal judicial influences as well. So this is when the Marshall Trilogy, and you'll hear that term if you study Indian law, all of the time. The Marshall Trilogy, they were all decided within 9 years of each other. First, we had Johnson v. McIntosh. So Johnson v. McIntosh is sometimes studied in Indian law classes, but every law student that studies in the United States actually studies that case in property. And it was really about Indian title. Does an individual have the right to interact and exchange land for either other land, for money, whatever it is? Does an individual have a right to do that exchange directly with an Indian tribe? And Johnson v. McIntosh said no. Then we had Cherokee v. Georgia. That's where this concept, and this is what we were getting at earlier with the question about trying to have sovereign to sovereign relationships outside of the United States with other countries. This concept of tribes still being sovereigns, but they are domestic dependent nations. That is an odd term, right? But really, if you think about it and you pull back, my example of there being sovereigns within a sovereign already, which were the states, you think about the American experience of a federal government dealing with states. They're like, okay, we can deal with an additional sovereign, but all interactions have to go through us. And it started with that Johnson v. McIntosh case. This is also where really that Indian trust doctrine really starts. Because now we have a term to associate that's easily associated with a type of trust. Because a domestic dependent nation sounds a lot like a beneficiary, doesn't it? And then we have Worcester v. Georgia, 1832, where we have a little bit of evolution. We're not quite to the unique political status that we have today. That doesn't come until the 70s. But they are distinct political communities. Tribes are distinct political communities. So it makes sense that during this treaty period, the policies that are being displayed, at least through their cases, kind of have this line, right? It tracks with the intent of the federal government to say, okay, we want you to thrive, but we also kind of need you to be in line with what we want to do with the rest of our nation as it grows. And again, Indian law is its own separate animal. We could spend a week talking about each of those individual cases and their influence on Indian law. Unfortunately, we do not have that luxury.
I have a question.
Sure.
In the 1831 with Cherokee and Georgia, wasn't Cherokee pretty well established? Did they have like their own?
Yeah, they had, well, so here's the thing. They all had, so all nations had their own government system. Cherokee, though, the Cherokee at that time in Georgia were recognized as, they had houses, they had retailers, they had traders, they were well established. So that domestic dependent nation was like, okay, we see that there's some change in your behavior, some evolution in your behavior. So you're still a nation, you're still distinct, and we get to those distinct political communities the next year, right? But you can see the evolution, right, from one to another.
I have a question.
Mm-hmm.
So this is where I just kind of have this relation to Kamse was a very instrumental component to then recognizing some of their internal structures, right?
Right. It was not only Tecumseh, but there were other Indian leaders at the time that were farther north, particularly of the 5 civilized tribes. So this was not the first interaction with tribal peoples, but because of the interaction with the 5 civilized tribes initially, and here, Cherokee, they had their own newspaper in Cherokee. at this time. So there was a recognition of something like themselves to westernize. So that's really what that was about. It wasn't about just an individual. It was really about the impact and how indigenous communities interacted with the communities around them. So here is an agreement between the Delaware Nation and the United States government, and this is in 1778, so this is brand new. The nation was brand new as a nation. And so they're already trying to create a military alliance here with the Delawares. And you can see all offenses mutually forgiven. That tells you that there were hostilities between the Delawares and the colonies. So they're saying, all right, we're going to clear the slate. We're going to start fresh with this alliance. We're not going to hold any grudges going forward. And then you can see the next section is about peace and friendship perpetually. So they're looking to the future. They're trying to create this strong alliance. And it's a military alliance as well, right? Because what's happening in the world? Well, we're still dealing with Britain. We have the French also vying for land to the north. So in the case of any war with any other sovereign, they will help each other out militarily. Makes sense, particularly for a new nation, right? Looking for as many bodies as you can, particularly to defend themselves against the British Empire, who they had just broken from. Even though the American Revolution was successful, they were still pretty skittish. It's a brand new nation. They were looking to be attacked, so they were trying to garner as many allies as possible. You can see that there is already an agent to be appointed by the United States to trade with the Delaware Nation. Again, we see, even back in 1778, the beginning of that trust relationship. Right? You have to go through the federal government to deal with Indian nations. And then we have down here, I think I took the next slide out, about the guaranteeing of territorial rights. Even though, let me move back, the treaty period was 1778 to 1871, I'm going to backtrack a little bit and talk about the 1820 to 1846. That 26-year period was an Indian removal period. And during this time, that's when, and we've already talked about why, there was lots of westward expansion going on. We had the Oregon Trail that was happening, so people were moving from the East Coast all the way to the West Coast, and by this time it had been well established. There was, again, federal legislation, the Indian Removal Act, that sanctioned this. Was happening in the 1830s, basically setting aside lands to remove Indians to. Talk a little bit more about this in the next section. But the Department of Indian Affairs was established in 1832. We have the Trail of Tears in 1836. And like I said, there are other things that were going on in this time that I could easily put on this board, but I chose this one. We also have the Treaty of Guadalupe Hidalgo, which I put up here, and while it's in 1848, it's in the next slide, but you see lots of changes. That was the end to the Mexican-American War. Lots of wars going on, lots of people moving from place to place. So of course they were trying to find a way to consolidate how they dealt with Indian tribes. And so most of the topics at this time were land exchanges. The Indian Removal Act was basically the creation of Oklahoma. The Indian Removal Act was like, this land area is going to be reserved for tribes. And that's why there are so many different tribes in Oklahoma, is because during this period they were removed from all parts of the United States to live in that small area of land. Here's a treaty from 1838. This is a treaty with the Creeks. And we start looking at the change in language even in the margin notes. the margin notes are saying certain claims relinquished by Creeks. Whereas before we were looking at that treaty from 1778, it all started with, oh yes, we are allies, this is friendship. So you notice a change in the treaty language is starting because of the impact of what is going on with the federal policies, right? It has direct relationship to the language that you see in the treaties and what the outcomes are. Now, the good thing is you start seeing also payment for any land claims are starting to show up. But as we saw yesterday, some of those treaties were signed for annuities that were supposed to go to 50 years and ended up only being 10 years. And this was happening throughout this treaty making period. Now it's not really an exchange in money that's going on now. The federal government is now saying, you know what, we're not going to give you the money. We're going to invest it for you and hold on to it and let it gain in value. So we see this trust relationship, right? Then we'll talk about payment to satisfy claims, supplies for hostile creeks. So while we're treating with you, we do know that there are some members of your tribe that might not want to be a part of this treaty. They're not accepting this alliance. So we're going to talk about supplying them and maybe subduing them in a way. So we continue on. As we're going through these time periods, think about those policies. Was the Indian Removal Act really in the best interest of the Indians? What happened to that sovereign to sovereign relationship? It starts declining, and it starts declining with that Marshall Trilogy. And as you see, statutes are being passed outside of the treaty language that are having direct effect on treaty language. So from 1850 to 1887, we have the Reservation Period. And you're like, well, why wouldn't you call the relocation period the Reservation Period? Because they're really not reservations yet at that point. That terminology is in some treaties prior to 1950 as reserves, but really the Reservation Period is from 1850 to 1870. I have identified because at this point, the Department of Interior, which is the year before in 1849, now becomes the head of Indian Affairs. So now we see what the federal policy is, because the Department of Interior has the Department of War, the Department of Land, and now it's over Indian Affairs. So there's a federal policy that is now affecting treaties and their languages, because now the focus of treaties really does focus on creating reservations and limiting land that indigenous peoples have access to and the right to use. You see how they start coming together, and you can start seeing that influence and the impact of what those topics are. What else is going on at this time? California Gold Rush is in full effect. So you have even more people than before headed west. Again, still interacting with tribes, still running into exchanges and clashes. Allotments begin in 1954. So very briefly, what is an allotment? This is the entire land that the Navajo Nation, for example, has. And while it's held in its entirety by the nation, what we're going to start doing is cutting up the land so that individuals can own that land in fee simple. So it's no longer a part of the communal land of the entire nation, but that individual Indian that has this allotment can now sell it to someone that does not have to be an Indian. So while you have the creation of reservations that are supposed to be solely for the use of those Indian tribes, there's this backdoor allotment that is still trying to gain even the land that has been reserved for tribes leasing it out, or taking it away from the tribe through its tribal members. Because now, remember in Johnson v. McIntosh, if it's tribal land, you have to go through the government. But now, if it's held in fee simple by an individual, you can now purchase that land individually, and it becomes private property, and it can become the private property of somebody who is non-Indian. And it was way back in 1854 that started the checkerboard phenomenon that you see on tribes. And the checkerboard phenomenon is, you within a reservation, you will have non-Indian land, non-Indians within the outer borders of a reservation residing there with different jurisdictions colliding, and it becomes a mess. And it's like that a little bit, even though it's kind of bad on the Navajo reservation, but it is nothing like it is in Oklahoma, because you can basically hop from one side to another and be in a different jurisdiction in Oklahoma. But that's the beginning of that. And so now what happens to that sovereign authority over your land? It starts to break up.
Didn't that happen during Andrew Jackson's presidency?
Yeah, that's all during this time period. We also have the Civil War in the United States going on. There are many alliances between tribes and the Confederates. So there are many alliances between the tribes and the Union. So it ended in 1861. And you'll notice in 1871, there was an end to treaty making. So after 1871, now you will see different land transfers. You will see amendments to treaties after that time period. But no new treaties happen. Even though some of them are negotiated, they're not necessarily ratified. And I cannot tell you with absolute certainty that all tribes knew that there was an additional process that had to happen after signing a treaty. In 1885, there was the Major Crimes Act that's happened. So while these treaties before this time have indicated the sovereign-to-sovereign relationship, the authority to impose laws within a particular land jurisdiction for a particular people. In 1884, I believe, there was a case called Ex parte Crow Dog, and a murder happened within tribal boundaries, and instead of a hanging, which was the norm in the 1880s, restitution was requested of the person. That person had to give over blankets, a horse, make sure that the family of the murdered individual had firewood. I mean, it was true restitution. Well, to Western eyes, that was not seen as justice. So the very next year, the Major Crimes Act was passed. And the Major Crimes Act gives federal jurisdiction to federal courts over major crimes like murder, kidnapping, rape. So it does not go to the states. It goes, if it's not in tribal hands, it's now in federal hands. Again, we have a statute that is basically abrogating the tenets of the treaty-making process. And that's why, if you look at population percentages, the population of Indian men and women in prison far outweigh the populations of any other ethnic group, because there is very little wiggle room. If something happens on Indian land to an Indian person and it is greater than a misdemeanor, it's going to federal court, not state court, to federal court. During this reservation period, of course, most of the topics are land exchanges and usually some type of supply exchange, and even some educational component. What I did not put in any of these slides, which I could have easily done, but again, it's a whole class, which is the influence of missionaries and religion on tribal peoples and the impact that it had on reservations. Because once you had all of the Indians in one place, it was much easier for missionaries to come in and discuss religion with Indians. I'll just put it that way. But they were also providing education that was promised in some of these treaties. Education for the children of those tribal people. So you had missionaries coming in saying, yeah, oh, we'll teach the Indian children to help fulfill these treaty rights. Well, religion and our tribal nations has had its own impact. Western religion has, but I'll leave it at that. But that is also happening all throughout this time period. Here's a treaty with the Utes, and this is in 1868. He talked about Andrew Johnson, and so you have contracting parties, Article 1. So now you see that former treaties are now being changed, right? So former provisions of former treaties, some of them are like, okay, those stay in place. But now we start seeing words like reservations more. We start seeing words like boundaries more. So again, the language has changed, and the impact of those policies during this time period have changed the structure of the treaties. They're starting to change the previous treaties, right, with new ones, setting more and more limitations. You start seeing more restrictions, only certain persons to reside within this area, claims to all other lands released, right? There are going to be 2 agencies on the reservation, so you're starting to see more dictation to the tribes about what's going to happen. Again, what happened to that sovereign-to-sovereign relationship? Is this in the best interest of these tribes from the tribal perspective? Because that's different, right? It's in the best interest of the tribe for the federal government's perspective. And you can even see the warehouse that's supposed to be built, and then we get into schoolhouses. And it even says a schoolhouse or mission building. So you talk about religion. Now religion is being put into the treaty language. These are the impacts of these federal policies on treaties. Because it's not just policies, it's statutes, it's all of these other influences that you can start seeing reflected in the treaty languages. You stop seeing the declarations at the beginning that say this is about peace and this is about friendship. Now it's about land exchanges, right? And finding a place to put people. So at this point, we're going to transition from treaties to statutes. This is all really heavy stuff when you really think about it. And for tribal people and their allies, when you really start thinking about it, you get so angry you don't know what to do. But hopefully by the end of this presentation, you'll see some light at the end of the tunnel. So we're going to continue on the federal policy timeline to current times, and it'll address some of the questions and side conversations that I've had about these policies and how tribes currently express their sovereignty. Do you see how important that word to me was? How you actually express your sovereignty. All right, so quick review of what we know about the United States and treaties and some of the changes. So who are the parties? Before they were countries, right? Or sovereign nations. Is that at this time period still true? Yes, if you look at it broadly, but the sovereignty of the Indian nations has now decreased over time, right? And you can see that in the treaty language and how it changes over time. Who now has the appropriate power? From the tribal side, how can the United States recognize who they are dealing with? Are they dealing with the chief of the entire Sioux Nation? Or is it just someone from the band of the Lakota Nation? Is it just somebody from Dakota? But the appropriate power used to be in the executive. And it still is because, we have the Department of the Interior now in play, which is an executive bureau. But really, with all of the legislation being passed, you start seeing Congress's plenary power really come into play. So they're no longer ratifying treaties. They're passing statutes that affect treaty language and the outcome of treaties and affect the lives of sovereigns of the Indian nations. you see the topics of treaties change. We used to see what would constitute a breach, like what would happen. Now it's just really the language of money at the end, right? It's the language of, well, where are you going to live if you don't live here?
Can you expand a little bit more on your comment of the sovereign nations and
Well, what have I been talking about through the Marshall Trilogy? So instead of just being a sovereign nation, they're now domestic dependent nations, right? They're a distinct political community, but now they have to go through the federal government in order to do anything with anyone. So sovereignty now is being expressed, but in a limited fashion because of the imposition of the changes in federal policy of the sovereign that recognized the sovereignty in the first place. So that's why I say it's been diminished. Yes.
Domestic semi-sovereign dependent nation.
Yes, and that's the language that has also shown up in case law. But like I said, this is not an Indian law class because you'd have to be here every day for us to get there. But you see it's starting to diminish in the expression, in the ways that these sovereigns can express their sovereignty. And that is what I meant by that comment. So who has the authority to make federal statutes? Well, we know it's the power shift is happening for tribes from sovereign to sovereign relationships to dependent domestic sovereigns, right? Because of all those influences that I just talked about. So I started talking about it in the other screen just to remind you what we thought a good treaty was about. Where are we at now as we transition from treaties into statutes? Let's look at that who, what, when, where, and why. Who are the parties? We've already talked about it. Yeah, so there are Indian tribes still involved, but really now it's their power and their expression of power is in question, right? Because right now, the legislative branch of the federal government has plenary power to create and terminate a relationship with the tribe, right? The executive still has power through their agencies. But again, what are the powers of the sovereign Indian nations at this point? And who does it affect at this time? All federally recognized tribes are treated the same. All of them. And that's still in effect today. What are these treaties and statutes about at this point? Any topic of governmental interest at this point. And I'm not talking really about the governmental interest of the Indian tribes, but that of the federal government. We're still in question, well, what constitutes a breach? Who defines that? Who decides that? What occurs when a breach happens? Is it a changing of a treaty? Is it a withdrawal? Is it a termination? But who is really getting to decide that now? Is it the Indian tribe anymore? It's a power shift. It's a paradigm shift. When can the law be changed? At any time now, with that plenary legislative power of Congress. And where is this happening? This is happening in multiple jurisdictions, and it's even creating new jurisdictions with all of these changes. So why is it happening? Well, it brings into question, where's that fiduciary duty, right? What about that trust relationship? We're still moving on to allotment and assimilation, and this is from 1887 to 1934. So during this time, we still have lots of railroads being built, right? We have the General Allotment Act of 1887. So we saw allotment starting, but then an actual act was passed in 1887. There is a identified Indian problem. Why after all of these centuries, are we still dealing with the Indian problem? Why can't they get civilized? We're all Americans now, right? And that really came out of the Merriam Report, which was in 1928. And really what that Merriam Report highlighted was what was happening in the Indian agencies throughout the United States. We saw poverty, starvation, lack of education, ineffectual management, because they couldn't figure out who they were dealing with. The Indian agents didn't know who the leadership was, because as we know, just like with any federal government or any government, Western government, there is a turnover in power. How did the Sioux break up into 3 separate nations? There was some disagreement. We're not going to do that. We're going to go do this. So how is the federal government supposed to do that? And because really the mismanagement of the Indian agents that we're dealing with the tribes, because the tribes did not have the language, they did not have the understanding of the processes. You want to talk about a veil of mystery. They just knew that they had to go to this place to get these things. And it starts being a part of their daily existence. And these things, I meant education, clean water, blankets, food. They knew that's where they had to go, because remember, they had been removed from the lands that they knew. They were limited in the hunting that they could do. So a dependency did happen during this time period. So here's February 8th, 1887. This is the Dawes Act. And you can see here the president authorized to allot land in severalty to Indians on reservations. It talks about how it will be distributed. What I find very interesting, that it talks about selection of allotments, what I find very interesting is this last part. So yeah, there are people that can say, hey, I can see that you're trying to break up our lands by doing this. I'm not going to choose the allotment. I'm not going to be a part of the process. There is a provision in there that says after a period of time, if you have not chosen an allotment will be chosen and assigned to you. So we have the Indian Organization Act in 1934. That's the Howard Wheeler Act. We'll talk about that in a minute. But the reason why we have such a drastic change from this allotment and assimilation, actually probably because it's very difficult for me to talk about, but the assimilation part, I did say, aren't we all Americans now? But what was happening is that children were being taken from their tribes, sent to boarding schools to separate them from their culture, their language. So they were no longer tribal people, but they were good American citizens. And I did mention yesterday that they did have ceremonies where men were giving over their bows and arrows and their hands were being placed on tills, because they were no longer hunters, they were now farmers. These things happened in our history, and it was happening, into the early 1900s, and we cannot forget that. This was not that long ago. The Indian Reorganization Act was passed in 1934. And part of this change happened was because in 1932, an Indian agent named John Collier actually became the Secretary over Indian Affairs. And he saw tribes differently from other Indian agents. He was sympathetic to their causes. He actually saw how they governed themselves. He saw that there was a disconnect with the interaction between identifying tribal leaders and Indian agents, because basically at the time in some of these agencies, anyone could come up to the Indian agent and say, hey, I am speaking for the tribe. How is the Indian agent supposed to say, hey, is this the tribal leader? And so during the time period before 1934, the reason why there was so much mismanagement is because factions were being created within tribes due to the treatment that they were receiving from the federal government. Some were accepting it, some weren't. And an Indian agent was more likely to create or have a treaty signed with someone who he knew would sign any document that they put in front of them, right? And not necessarily the entire voting population of a tribe. In 1934, we have the passage of the Howard Wheeler Act. It's called the Indian Reorganization Act, and I'll talk about that here in the next slide. So we have that happening, and basically it was an act giving tribes the opportunity to move from their culturally relevant, organic state mechanisms, their self-governance that had come from their nation, from their shared history, from their culture, and superimpose some state mechanism that looks more like a Western style government. And we'll talk more about that in a minute. But also during this time, there was this Legislative Reorganization Act of 1946. What this act did is, up to this point, there had been special committees within the Senate and within the House of Representatives that was dedicated to Indian affairs. This act actually wiped them out for a period of time. So you have a couple of things going on. So in 1934, you're like, oh, okay, well, good. We're trying to create a better relationship with tribal entities. But then in 1946, you're like, oh, wait a minute. Now there's no one dedicated to looking at Indian affairs. And why is that? It's because we still have assimilation going on. There is a kind of break in the federal Indian policy. There's a shift going on, but we're not quite sure what else is going on. But you got to remember, particularly in the 1950s, we have McCarthyism going on. We have Eisenhower. Americans are turning on Americans. There's this greater political paradigm that's going on, and we're trying to figure out who is American enough. And so they're like, well, why do we have this special status? There are some residual claims that are now coming regarding treaties and the language used in treaties. So there's the creation of the Indian Claims Commission. Also, some of the allotment issues are starting to brew up, which is also going to the Indian Claims Commission. And in 1948, there's actually a federal definition of what is Indian country. So we actually have a federal acknowledgement that Indian country is a distinct jurisdiction, which is really an evolving term from what it used to be. Now, let's go back to that definition of a sovereign. The sovereign has the power to regulate, impose laws over a particular land or people. Indian country actually gave that type of jurisdiction a title, and it becomes very important, particularly now. For instance, here in New Mexico, if you look at Taos is my favorite example, that Indian country around Taos is all of Taos, even those lands outside of the Pueblo, because historically they were Indian lands. So it starts all back in 1948, and I guarantee if the federal government knew that this is the way it would go, they would not have done it. Before I talk about the Indian Reorganization Act, let's talk a little bit about tribal governments. So tribal governments have existed since time immemorial, and the way they've been expressed, however, does not easily translate into a Western concept of a civilized, and I'm using air quotes, government, right? So there's an extremely wide variety, because usually when we're talking about Indian land, we're talking about tribal peoples. All the tribal peoples get lumped in together like they're all the same, and they're not. They're different lands, different cultures, different languages. So there's this wide variety of how they actually govern themselves, right? You have nomadic bands, and I use the Sioux, they voted with their feet. They're like, all right, well, we're going to go create a new band then. We're still Sioux, but we're a different band. They're highly structured, complex, and stable. A lot of them are clan-based, right? The legitimacy for the sovereignty of Indian nations comes from creation and sacred narratives, not from any written constitution. And this is the problem when the Europeans came over and so used to seeing some type of constitution or republic, right? Kinship groups rather than individuals were the basic unit of the political structure. So there's no king. Responsibilities are divided. A lot of times, sure, it's based on your birth, but not in that same way that European peoples thought of it. So while I said there are tribal governments are vast and wide, and Indian people are different, when I talk about tribal governments here, I'm going to focus on the similarities in most tribes. There are always outliers. But for the most part, tribal governments are directed more to resolving conflicts, right? Restoring harmony to the community. If punishment happens, it's for the good of the community. The legislative action isn't the same as we think in the Western culture of creating a statute, right? Because it depended on what happened, what the circumstances are. If there was some type of council, it was consensus-based. It might not have been completely democratic, right? But the development of tribal governments as they are today are impacted by colonization and outside pressure, and we've talked about some of that in our side conversations. So Western eyes see it as, well, wouldn't this government be more effective or more efficient to have a king or a chief in place, right? And there were some deliberate tribal efforts over these time periods that I'm talking about to modify so it did make it easier on the community to communicate with these outside influences. So there was some evolution happening, because one of the questions I put forth when we're talking about tribal governments is there a limitation to evolution for a tribe and its tribal government? Does that only have to be one thing and only that thing always? Does what a tribal government look like affect its legitimacy? And we can see that it did over these political landscapes, right? You think about the nations and states, the construct of a state, for a state to work really well, it should have come out of the nation, out of the culture. And I have to stop and talk about this because now we're going to talk about another federal statute that imposed a Western-style state mechanism to make it easier for the Western-style state to deal with these nations that had a different origin story, a different culture. It's the Wheeler-Howard Act of 1934. You'll hear it referred to as the Indian Reorganization Act. The tribes actually voted on this, so there was some tribal consultation. At the time, the tribes had the right to organize and adopt the Constitution and bylaws for their particular tribe, and that 181 for and the 77 against was actually in Congress. So tribes could opt into this. So they had to go back into their Indian communities and have a vote of whether or not they wanted to make these changes. Not all tribes did, but a number of them did, and those are the tribes, most of the ones that have a constitution now. That sounds familiar, doesn't it? A constitution? It's because that concept for tribes was actually created through the 1934 IRA. Now I say that when really the concept of a constitution comes from the 5 civilized tribes, and the United States actually stole that from the 5 civilized tribes. But again, that's another class. So there was a template that was given to all of the tribes that said, okay, so here's your fealty to the United States. Here's a section for how you're going to choose your tribal chairman, a tribal council. Here's an option for you to put in a clause for how to define your membership. So up to this point, we really haven't been talking about tribal membership, except for maybe in the allotment era, because they had to figure out who were the members of the tribes so that they could give them land. And so now in 1934, well, who is your membership? Identify it. So some tribes actually did put in that tribal membership clause as is, with these random blood quantum things attached to them. But that really was an artifice. It was constructed. Blood quantum was not anything that really comes from tribal peoples themselves. Blood quantum was really a concept from the federal government to show kinship, to figure out who to give allotments to and when to cut off federal support. Yes?
I think it was another plan for termination, because blood quantum is kind of a crazy concept, but eventually with intermarriage and eventually it's going to just decrease.
Correct.
You know, I mean that it may take 100 years, but on its own you're gonna
because it's finite, right?
Yeah.
And you can set limits easily with something that is quantifiable.
Well, that's where having that sovereign status, you can change that.
Absolutely. And that comes with Santa Clara v. Martinez, which, again, is another class. I'm not going to go over that today, but you're absolutely right that part of the sovereignty that tribes can still express themselves is to define their membership. And many tribes now have backed away from blood quantum and are actually looking at cultural ties, whether or not you know the language, who your ancestors are in a different way from blood quantum. It's like what is your line? And that actually goes back to kinship, right? And clan, right? Who is your clan? Which for most tribes is matrilineal, right? Because it's easy to identify a mother, sometimes harder to identify a father. Yes?
Are there any tribes currently operating now that opted not to take on the Western structure?
Oh, there are a lot of them.
Okay, yeah. I mean, white girl from New Jersey, I've never heard of any that didn't have sort of centralized Western power.
Right. No, there are a lot of them that did not. The Penobscot, I think, they are still... So they do have a council, and they do have a chairman, but it's actually a council of the women elders who chooses. It's not a constitutional thing. There are many tribes that did not. I think at the time only 121, I think, within the first couple of years. My numbers are off on that because it's very hard. Nobody thought about counting who became an IRA tribe, and it's very hard to find the actual numbers. There are some resources through OU Thorpe website that actually lists the tribes, but I have over the years called the BIA to ask them if they have a list, because if anyone should have a list, it should be them. A good list, right? They do not. They think I'm insane. And even when Kevin Washburn was the assistant secretary, I said, you need to do that. Hire me. I will go through the records to do that. But that's something that somebody needs to do. But there are unofficial lists out there. Now, you've noticed we're not really talking about treaties anymore because treaties have now morphed into statutes. So this is from 1840. And this is the acquisition of Indian lands for the Parker Dam and Reservoir Project and for other purposes, right? We're looking at the acquisitions of Indian lands for something else. There is money that's going to be paid to the Indians. We're looking at deposit amounts to tribes. Again, the money is being held somewhere. Maybe it's being distributed. Maybe the count is accurate. Maybe it's not. Termination and relocation. It looked like we were moving forward, right? With the Howard Wheeler Act. Tribes are now looking more Western. It seems like the relationship between the United States and individual tribes would be better. But from the 1953 to all the way to 1968, there were termination acts. And that started with the House Concurrent Resolution 108 in 1953 that called for the ending of the dependence of tribal nations, or Indian tribes actually is what the wording is, on the federal government. So at this point, where is the sovereign for the Indian tribes? Who is making the decisions anymore? It is the federal government. Very little input is happening with the tribes, right? Also in 1953, there's the passage of Public Law 280, which transfers criminal and civil jurisdiction to the states. Now, it was originally 6 states, and when they did it originally, they didn't ask anybody. They didn't even ask the tribes. The federal government just imposed it. Now, PL 280 has since changed. States have been added. At this point in PL 280 states like Arizona and California, tribes can opt out. Arizona is a PL 280 state in which Arizona state courts can oversee civil and criminal actions that would normally go to a tribal court, but in state court, and they would even actually apply tribal law. This happens in California and Arizona all the time. But now tribes have the option to opt out. So for instance, in Arizona, the Navajo Nation has opted out because they have their own tribal court system. Okay, because in the federal government's view, this was to help those unorganized tribes that did not maybe have the resources to have their own adjudication systems. And then we have termination of tribes, just outright termination from 1958 to 1966. And this is that plenary power that Congress has. They pass statutes terminating the sovereign status of tribes.
What kind of justification would they use? That might be a bigger question than you.
The justification was the federal policy. Why can't they be self-sustaining? Aren't we all Americans now? Now you got to remember, if you look back at the history you just talked about, there's already an identified Indian problem. They're already trying to assimilate. There is pushback that is happening at the tribal level. I don't want you to take away from this that the tribes are just sitting back and taking this. That is not the case. But it's happening at such a high level that it's very hard to fight back against, because that sovereign to sovereign relationship and that expression of sovereignty has been so limited to this point, right? And so we have a Termination Act, and if we look at the wording, to provide for the termination of federal supervision over the property of the Wyandot tribe of Oklahoma and the individual members thereof, and for other purposes. And now you really need to see who's on the membership roll, because we need to get rid of their monies now. Were they allotted land? You start needing to track all of these things. Because if you take it from the governmental perspective, in the most positive light that I can put it in, why are we interacting on the behalf of these people anymore? There's so few of them. Shouldn't they just be U.S. citizens? Is there really even a status there? And you can look at the legislative history behind all of these acts and actually get the real answers behind every termination, but it did happen. So we've talked about the dire history, and I didn't even go in depth about it, right? Because it's a little too much for all of us. But let's start wrapping up, because where are we now? I have this on my timeline as self-determination starting in 1968 moving forward. I think actually we're in a post-self-determination phase right now, but I'll think about changing my timeline at another time. The reason why I chose 1968 is because that was the passage of the Indian Civil Rights Act. That was a change for Indian people of being seen, of having a direct relationship with the federal government, with their own governments, right? It was the exercise of treaty rights through the courts started happening in the 1970s. Hunting, fishing rights were wanting to be fulfilled. And so you're starting to see those cases, particularly in the Northwest, start coming into court. 1971, we have the Alaska Native Claims Act, right? So while it's an extinguished Aboriginal title, the tribes got something. They got some sort of status, right? The Indian Education Act passed in 1972. The restoration of tribes begins in 1973. Morton v. Mancari, when I talk about that unique political status that is not a race-based thing, it is a political status. It has nothing to do with blood quantum. It has nothing to do with race. 1974, Morton v. Mancari. And the reason why that was so important is because of the Indian preferences that you will see in applications by tribes, and in the BIA, you will see that Indian preference. And if you're talking about equal protection, well, if it's race-based, it's not allowable. But if it's based on a unique political status, it's okay. And Morton Mancari actually protected the ability to do that, to have Indian preferences. So you have Indian people working for Indian tribes, working on Indian issues. We have the Indian Child Welfare Act of 1976. During this time, there's also Santa Clara v. Martinez is right around the same time, in which the Supreme Court says that tribes, as sovereigns, have the power to define their own membership. That is a big deal. Then we have Indian Gaming in 1988. That's a federal act. And then in 2011, we have the Tribal Law and Order Act, which now we started with the Indian Civil Rights Act of 1968, which gave some protections of the Bill of Rights, because remember, still during all of this time, we as Indian people in that particular status of belonging to the citizenry of a tribe did not have the same coverage of the Bill of Rights. So we have some through the Indian Civil Rights Act, but the Law and Order Act basically filled it out when it came to criminal law, because we had more and more things happening in tribal courts. We see what happens to Indian people in other jurisdictions. How do tribal courts really maintain their power to oversee their jurisdictions? The Tribal Law and Order Act does that by imposing for those tribes that want to opt into it requirements of establishing a public defender's office, making sure that their judges are law trained, making sure that there's access to the tribal laws. This makes a really big difference for Indian country, but it comes with its own issues. We are in a good place now. You see a lot of economic development happening within tribal nations, but it took a long time to get here, and it is still all very perilous. And why is that? It's because federal governments are impacted by federal courts' decisions and policies. We're now domestic dependent nations and other derivatives of that term. Congress has the power to limit tribal government powers and to restore them. Even the existence of tribes through a legislative act. And we can see that through the Major Crimes Act, through the Indian Reorganization Act, through Public Law 280, not to mention the Termination Acts. Right now, tribal governments are now traditional, constitutional, and hybrids. And it's because of the impact of those treaties, those policies. That is the impact that we've had on our government. There are still tribes that operate without written constitutions. We have direct democracies like the Penobscot and Oneida of Wisconsin. And we have many of the Pueblos don't have their own constitutions. There are formal agreements of coexisting with traditional governments. So you will have your councilman, and like in the case of Pueblos, you'll also have your cacique, right? You have someone dealing with outside tribal matters, and then you have somebody dealing with internal cultural matters, with sacred matters. So that's good, right? Because now you have a protection of the sacred, but you still have an outward face and outward contacts with others that don't cross a line. And it takes some of that mystery out for those outside eyes. Here's 1973. This is Reinstatement Act. So this act is repealing the Termination Act for the Menominee. And this came in 1973. And you see the Menominee Restoration Act, and very clearly Menominee Indian Tribe and federal recognition. So now this is a prime example of what plenary power is and why it's important, how it's impacted the evolution of treaties through time into their current structure. So as of right now, over 200 treaties are still in effect. Now they've changed. Congress still has plenary power, and tribes are more vigilant than ever with their rights, right? They are expert lobbyists now. Federal statutes have taken the place of treaties. They are no longer sovereign to sovereign, not really anymore. Disputes are resolved in U.S. federal courts. For the most part, like I said, there have been some exceptions to going outside of the U.S. system. Federal statutes can abrogate treaties. The trust relationship can abrogate treaties and their language. And even though the canons of construction apply to both treaties and statutory interpretation, you have to take all of those things together, and really most of that power is placed on the federal government and whatever their federal policies are. And that is why we have so many more Indian law advocates, so many tribes have tribal attorneys, in-house counsel. We have the creation of Native American law think tanks and representatives like the Native American Rights Fund. And that's where we are. It was produced through really the interaction of treaties and how treaties have changed over time. Yes?
When it states federal statutes have taken the place of treaties, does that make Native tribes more vulnerable to the U.S. diminishing completely the treaties between that?
Yes. Well, as you see, at any point, regardless of whether or not a treaty is in place, right now, the legislature can pass a statute terminating the status of any tribe, regardless of a treaty. That's exactly what it means. And it's a hard pill to swallow, and you're like, how can this happen? It's already happened. It can happen, and it can happen again. And that's why tribes have become so strong currently, have been trying to become more economically diverse and independent and strong, making sure that their education systems are stronger so that they can deal with the federal government legally. We're sending more and more Native representatives to the federal government. But it's a struggle, right? Because the more you go outward, the more you have got to balance what it is you're trying to protect, the culture, the language, because you're sending people out. You have a brain drain, right? You're sending your best out to get their education, to represent your people, but they are no longer home dealing with internal matters, right? Because remember, all of these treaties, what they started out with were external matters. But now they have transformed over time through treaties to start involving more internal matters.
So then, the way I'm understanding this is, if this has happened to the treaties, then it also impacts the tribal sovereignty, to where the tribal sovereignty has diminished along with the treaties as well. So in some sense, we are moving towards becoming powerless, to where we can really keep a treaty in place when it's already been replaced by federal statutes.
Well, here's the thing. You are trying to keep a treaty in place, and you're trying to make sure it doesn't get overturned. That is why every Indian law case that goes up to the Supreme Court is so important, because it might only be about one tribe, that particular case, but the effect impacts all federally recognized tribes. Every single one, regardless of their membership, regardless of how well developed they are, it does not matter. And you're struggling with that realization going, oh my gosh, yes, it is that precarious. It's why we have Indian law scholars creating these wonderful briefs, creating more books about federal Indian law, specifically about treaty rights. It's why Cohen's Federal Handbook has been of such use over the years. It's not that the tribes are wanting to get weaker. I like to look at it, that period of self-determination is because of this, they're finding ways to get stronger and finding other avenues to exert their influence. And it's happening. Is it still a struggle? Sure. I mean, look at the San Francisco Peaks, right? Look at just about any sacred place in the United States. There's always a struggle between the federal government and their tribes. I mean, Blue Lake.
Yeah, that's
And to throw this into the international arena, the movie that came out last year, The Woman in Gold, that's a perfect example of what the basis of Indian claims and policy apply to an international situation with that woman that was based on our U.S. Property rights.
Right.
That movie, if you go into depth, that was based on our Indian nation's laws and property rights that apply to
someone else. So we're at the end of the presentation. I know some of this was really hard to hear. It's hard to digest, but I hope the presentation gave you some really good foundational knowledge so that when you're doing treaty research, when you are thinking about federal statutes or you hear that another federal regulation is coming down or another federal statute is coming down, you understand why it's so important and why we have to pay attention and why we have to give feedback. And it's because we really need to remember the history of our treaties and how they have morphed into today. Thank you so much for your time and attention.